Hi, everyone. Good afternoon, good morning, good evening, depending on where you're on the globe. Welcome to this exciting panel discussion on the promise and perils of strategic litigation in digital rights. Before I introduce the panelists, a little bit of context on why we are having this conversation. In the past few years, strategic litigation has emerged as a key tool of advancing digital rights across the globe. But like any other tool, it's important to understand under what circumstances does this tool work and under what circumstances does it not. Secondly, courts all over the world, especially in the global south, don't have a great track record of consistency and can therefore sometimes be unpredictable. So we want to discuss what are the unintended consequences of using this tool for its purposes. And thirdly, some countries and some civil society organizations have used this tool a lot more than others. So what are the lessons from their journey that others can use to start their own digital rights journeys in their respective countries? So to discuss these questions, I have a great panel that I'm looking forward to because they're all stalwarts in this field, and I'll introduce them one by one. So first off, would like to introduce Vrinda. Vrinda is an independent legal practitioner who works on a variety of digital rights and privacy issues. She has litigated issues relating to internet shutdowns, biometric digital IDs, contact tracing apps, surveillance, intermediary liability, and WhatsApp privacy policy before courts in India. So welcome, Vrinda, and glad to have you here. The second panelist we'll have is Olumide Babalola. He is a lawyer and co-founder of Digital Rights Lawyers Initiative, a network of lawyers who facilitate defense of digital rights. His digital rights litigation experience spans across all superior courts of records in Nigeria and regional courts in Africa, including the ECOWAS Community Court of Justice. An awardee of the Nigerian Rising Star Award 2018, he is a member of the Nigerian Bar Association, British Nigeria Law Forum, Internet Governance Forum Support Association, Chartered Institute of Arbitrators, and International Bar Association. Welcome, Olumide, and glad to have you on this panel. And last but not the least, Nani Jansen Reventlow is a human rights lawyer specialized in strategic litigation and freedom of expression. She's founder director of the Digital Freedom Fund, which supports partners in Europe to advance digital rights through strategic litigation. She's also the initiator of the Catalysts for Collaboration project, which offers best practices and case studies, encouraging activists to collaborate across disciplinary silos and use strategic litigation in digital rights campaigns. So I don't know about the viewers of this panel, but I definitely am extremely excited to have this conversation with all three of them. And before I get started with the proceedings, just a few housekeeping rules that please do keep your questions flowing. Please do type it out in the window and we will try to take up as many of those as we can answer. But this is, of course, a much longer conversation. So for those of you who want to keep this conversation going, I believe all four of us are on Twitter. Feel free to tweet at us with your thoughts, and I'm sure we'd all be glad to respond to the extent possible. So with that, and we're having done all of that introductory work, happy to dive straight in and to level set and get all of us on the same ground and talking about the same issues. Would love to start with asking each of the panelists in turn about perhaps their most interesting strategic litigation case in digital rights, and in particular, what got them started, how did they get into it, how did it proceed, and what was the outcome of that? And of course, in this case, interesting being very widely defined, so please interpret it as you like. So with that, I'll get started. So why don't we ask you, Vrinda, first, if you can tell us about your most interesting case here.
Yeah, I think, like you said, interesting depends on how you define it, but I think something that is probably the closest to my heart was the internet shutdown litigation in Kashmir. This is, you've always read about internet shutdowns and you've kind of, you know that it's been happening in Kashmir, but really litigating this issue brought home to me just how difficult, what it means to have an internet shutdown. So to give some context, in August 2019, there was a change in the constitutional status of Jammu and Kashmir, and that was accompanied by a full communication blockade. So no phones, no landlines, no internet, 2G, 4G, no TV, nothing. So it was an effective communication shutdown, and things opened up slowly, but for over 200 days, there was no internet. And then, we had moved the Supreme Court. There was a judgment that we got. The court didn't really look at, and so, we can later go into kind of the pros and cons of strategic litigation. The court recognized, the importance of internet access, but it didn't really go into the actual orders that were passed, and it didn't, decide the legality of those orders. However, there was a 2G restoration that happened. And then we litigated again saying, look, we're in COVID, 2G restoration doesn't work, 2G it's not good enough, we need 4G. And then, it took another 100 or so more days. So basically after 500 days is when Kashmir finally got internet access. And I think during this process, I learned so much from, from the experiences of people there, from reading about this, from really understanding the costs and benefits. And India, as you all may know, is a country where internet shutdowns have almost become normalized. Everyone has, or many people have experienced a shutdown, including now myself, because the capital city has also experienced an internet shutdown. So I think given that we now see this increasingly used, especially in Asia and Africa, as a tool by various governments to shut down communication, I think this is it's a strategic litigation that's going to be ongoing. And so I think that for me has been very interesting. We did succeed to some extent, but I'm not sure if it was just because of us, it was international pressure, what it was, because the court unfortunately never decided the legality of the shutdown orders. So the government on their own restored internet. So that's something maybe we can go into later.
Yeah, I would love to go into that later. And the fact that it took 500 days for this kind of judgment to come, I think is an interesting insight there. Olumide, now let's turn to you, and would love to, obviously we worked together in many ways, and have heard so much about so many cases that you have done, especially in the recent past. Which one of those to you has been kind of the most interesting one, and kind of what got you into it? Hi, Olumide, can you hear us? You might be on mute.
Sorry. So I'm so sorry about that. My journey actually started in 2015 when about 3 NGOs came to my office, and at that point we actually wanted to litigate a social media bill. I mean, that the government wanted to pass. So while we were litigating that, they came back to me and they told me they wanted me to check an existing law, which is our Cybercrime Act. The Cybercrime Act, Section 24, Section 38 of that law seeks to regulate free speech, seeks to criminalize opinions, because the provision says that if anyone sends an offensive message to another person, then the person has committed an offense. And that law does not define what an offensive message is. The law does not define what is the parameters of grossly offensive. But we discovered that it's when you send those messages by the use of computer that you have committed an offense. So we had to litigate that provision. We had to challenge it in court to say that, this provision is too nebulous, and it puts a chilling effect on people's opinions, on their free speech, because you never can tell what is offensive. And what is offensive is always relative. What is offensive in Africa might not necessarily be offensive in Europe. What is offensive in my community might not necessarily be offensive in another community, in another part of the country. So we approached the court. Unfortunately, we lost at the Federal High Court. We approached the Court of Appeal. We lost again. We went to the Supreme Court. But before the Supreme Court would decide, we went to the ECOWAS Court, the regional courts. And happily, we got judgment at the regional courts. Although, yes, we have enforcement problems, because, I mean, the regional ECOWAS Court is not immediately enforceable in Nigeria, but you have to go through some processes or even approach the politicians or the Attorney General to make it. But that case kind of opened my mind to digital rights, and it opened my mind to the possibilities around digital rights, and the number of shutdowns, like Rita said, that has occurred in other parts of the world, and the digital rights that people have actually litigated. That was actually the time I discovered Nani. I mean, I wouldn't have known about Nani if it wasn't for that case. So I had to do a whole lot of research, and I saw people who have done a whole lot of things around digital. So for me, it was an eye-opening thing. And because it cuts across, it cuts across. Everybody has a digital right. Everybody has an interest. Everybody is the stakeholder in digital rights, and that's the interesting thing for me. So you don't just, it's not just like the regular human rights that you can say, your right to life or personal liberty or dignity. But for as long as you have something to do with the internet, then you are a stakeholder in this digital rights battle that we all found ourselves. So that's the interesting thing for me, the fact that it comes across. Thank you.
That's an interesting thread which we should probably pick up later, which is in these kinds of litigation, it's almost like there's so many different stakeholders and who's kind of the adversary kind of keeps shifting. But holding on to that thought, Nani, would love to hear your thoughts on what's been the most interesting case you've been part of.
So I'm going to be a little bit subversive and kind of like flip your question ever so slightly. And I think it builds nicely on what Vrinda and Olumide just said. Because like the cases they refer to weren't necessarily cases that where you had like a clear win in court and therefore you had the impact that you were trying to pursue. Because one of the things that I always think is really important to keep in mind when you think about strategic litigation is that you can have impact in many different ways. So I wanted to flag like really briefly, like 3 different cases that illustrate that. So one is that you can actually have impact already before you file your case. And one of the cases that we supported in the UK was work by an organization called Big Brother Watch that was challenging the use of digital strip searches, if I can put it that way, by the UK police. Very briefly put, police there, if people file a complaint about sexual assault, the person filing the complaint has to hand over access to all their social media. So very, very good to kind of like understand there. It's not the person being accused, it's the person actually filing a complaint. And this is something that they were preparing to provide evidence in litigation that was brought by another organization. And before they even got to that point, the police indicated that we're going to change these practices. So that's kind of an example of being able to have impact before you even actually go to court. And I'm going to try and multitask and actually put some further links for reading there, because I'll keep it short. Then, of course, the traditional example is actually winning your case. And a lovely example there is a victory last year in the Netherlands by a coalition of human rights groups that challenged the use of an algorithm by the Dutch government in which they were trying to preemptively detect potential benefits fraud. So they combined data from a whole bunch of government databases, ran an algorithm over it, and kind of tried to kind of like get people flagged who might be likely to commit fraud in the future. So mind you, nothing about actually having done anything, but just maybe you could be committing fraud later on. And if you were flagged by the system, you were subject to further investigation, which makes it, of course, very likely that you then also will find something there. This was rolled out in communities that were high immigration, low income, so there was also a huge discriminatory aspect there. And this was found to be in violation of the right to privacy. This is a really nice win that kind of like, because it's a first of its kind, can have huge impact also in other jurisdictions. So that is one that I wanted to flag as a win. And then there's also the possibility that even if you lose your case in court, or if you don't get a judgment, like Vrinda was just illustrating, you could still bring about greater awareness of an issue or public debate about something that is really of great importance. And an example I want to flag there is an initiative in Chile. In 2015, local authorities in Santiago let loose military-grade balloons over the city to kind of like look at traffic patterns, but also to monitor crime, which of course is a huge violation of everyone's privacy to begin with. This was challenged in court, initially successfully, and involved in that were Derechos Digitales and Datos Protegidos and other collaborators that they worked with. Initially successfully, but unfortunately the Supreme Court in the end found that even though it wasn't entirely up to scratch, right? There weren't sufficient safeguards for privacy. In principle, using this type of technology was possible. What was a great win there is that because of their campaigning and their very effective messaging to the broader public, people became much more aware of these issues and have become more vigilant about when and how new technology is being rolled out. So those were kind of the ones that I wanted to flag, because there's too much to choose from.
Great, thanks. I mean, now we've kind of got these 5 examples of partial wins or full wins of basically the promise of strategic litigation in digital rights. But especially if you take that 3-part framework, Nani, that you said, if you look at the central part, right, which is to an extent everyone would want to be successful in that central part, which is inside the courtrooms. Have you seen in your career some generalizable lessons or observations about what increases the chances of success in that central bit of your 3-part framework? Yes, Nani, that was a question to
you. Sure. So I think a number of things are really important in making strategic litigation as impactful as it can be, if you win or if you don't, right? One is that it's really important to make sure that it's connected to other efforts. Like I always like to refer to strategic litigation as one of the tools in the toolbox. It's not the be all end all in any cause. If you think about bringing about broader change, be it in legislation, be it in policy, be it in practice, you have to also look at other ways to engage. So that can be generating public debate, it can be advocacy work, it can be policy work, lobbying, etc. All of those things ideally come together around a case. This also helps kind of like laying the groundwork for proper implementation if you actually win a case, because just having a good judgment, that's not everything. Olumide just pointed to that as well. You need to be able to actually implement it, and you need to have social support in order to get the implementation done. But also it allows you that if you lose, to kind of potentially leverage the loss into a win. You can have a situation in which you have generated such public debate, public outrage about an issue, that if you lose in court, people will push for example, the legislator to bring about the change that you're trying to pursue. So it's about this collaboration aspect between different types of disciplines, and making sure that those all work in tandem. And one other thing that I think is super important is really having a good longer term vision and not wanting to get there in one case necessarily. There's often kind of like, for us lawyers, this idea like, I'm going to solve this with this amazing impactful case, and after this, everything is going to change. Whereas in certain situations, you just have to kind of like take an incremental approach. You have to take case after case after case and kind of like build towards this change that you want to see. A lot of like the bigger impactful decisions that are very clear in our minds. We think about equal marriage rights. If you think about even like things like big tobacco or anything like in the US, those are all the results of much longer term campaigns in which people have been very clever about how to chip away at the block. And I'm going to put another little link in the chat here about some best practices for collaboration in litigation.
Great, thank you so much, Nani. That's incredibly insightful, and especially for folks like me who are non-lawyers, so we are always away from that middle step. So I think it's also great insight on how we can possibly contribute to what goes on inside the courtrooms. But with that, I'd like to pose the same question, Olumide, to you as well, which is, you've now litigated a number of cases. Where are you seeing success, and what's causing that? Hi, Olumide, you might be on mute.
I always forget to unmute my mic. I'm so sorry. So first of all, for me, personal experience, once you find so many people who are interested in funding strategic litigation, first of all, talking about the Nigerian lawyer, you are, first of all, inspired. Now you see a whole lot of organizations that are interested in funding it, because litigation could be quite expensive in Nigeria. So you have some support. So part of the successes we've been able to record were because we had support. We had support within Nigeria, we had support outside of Nigeria, not just monetary support, we have resources. I recall when we were filing the Court of Appeal briefs, we had partners from the UK that supplied us with resources. From India, the examples of such decisions in India, the one in Kenya, the one in the UK. I know that was what, while we were doing all the research, I stumbled on some of the cases that Nani had also done, and we were able to put. So once you have so much to convince the court, it makes you extremely happy and confident to actually approach the court and tell the court, this is something that has been done in some other jurisdiction. So first of all, funding. Secondly, collaboration that Nani mentioned, the fact that you could get materials from all over. Then third, when you have willing plaintiffs, some of these matters, they are strategic, but for Nigerian judges, for some Nigerian judges, they want people who have actually experienced the violation firsthand. So you are not coming just as a speculator, or you are not just coming as a busybody, but maybe you have a plaintiff who has actually experienced or who is in danger of such violation. The part of the cases we filed, they were press organizations. There were organizations who were involved in reporting matters, who were involved in constant expression of their opinions in the press. So it was easy for us to convince the court that, come, these are the people who will come in direct contact with these provisions, and they are likely to suffer violation. But sometimes when you don't find a willing plaintiff, it's always a problem. So for us, the successes are hinged on, first of all, funding, second, collaboration from within and outside Nigeria, I mean, for organizations that are interested. Then third, you find a willing plaintiff who is ready to put himself on the line to approach the court. So that's what has encouraged our own strategic litigation in terms of digital rights violations.
Nani, you have your hand up, so why don't you go ahead? I
just wanted to echo what Olumide said about the importance of being able to share information, right, about these cases. Because I think that one of the things that is really important for us who work on digital rights issues on a regular basis is really important to keep in mind that it's not so cut and dry for the judges that we ask to decide on these cases, right? And I always feel that it's super important to give judges the level of comfort that they need in order to kind of like decide that you want them to decide. And one of the things that is super helpful there is kind of like seeing how other colleagues, and if there's no jurisprudence available within the country, then it is helpful to bring in those decisions that were made elsewhere on these still very new issues for courts at the moment. So that information sharing aspect is super important.
Yeah, but Nani, building on your point around judges, and I'll pose this question to Olumide, which is, one of the questions, Olumide, that I've always heard is, what is the level of understanding that judges have about these tech policy issues? Because these are extremely complex, nuanced things which even the best of experts don't know enough about. So is that a challenge that you have faced where you felt like, hey, there's almost like a education required before litigating some of these things? And how have you sought to address that challenge?
Was that for me?
Yes, Olumide, that's for you.
Oh, thank you. Just like what Nani said. So, I mean, putting the judges in a comfort zone is also very, very important. We have seen it in several cases that you try to explain, especially the three-part test. I have not seen any decision in Nigeria where the three-part test has been used. And so you want to start explaining to the judge what the three-part test is, the cases in other jurisdictions where they have been used, the decisions of those jurisdictions, the facts and circumstances of those cases. So it is very important. In our Court of Appeal decision, the judges acknowledged that, yes, we brought huge, very rich resources to them. I mean, we cited decisions from Kenya, cited decisions from India, cited decisions from the UK, the Big Brother case. I mean, there's this very popular case in the UK. I mean, because our law was copied. It was copied from Singapore, copied from India. And I understand that same provision that was in the Indians ITU. I think, was it India that has the Information Technology Act or something? And yes, I mean, the same thing with the Kenya too.
Yeah.
Similar provision. Yes, similar provision, but India had gone to court to challenge it, and the Supreme Court of India had ruled on the unconstitutionality of that provision. The provision that has anybody that expresses a grossly offensive message would either pay a fine of 7 million naira or go to jail for 10 years. So in other jurisdictions, we were able to bring it to the court's attention that in other jurisdictions where we copied this provision, they have moved on. And it is important for us to move on. And what is comforting is that the third judge, the third justice that gave his own decision actually mentioned it in his decision that it was important for that provision to be amended or that provision to be reviewed. So I tell you, it is very important when you bring all these things to the judge's attention. Sometimes judges might be, I don't want to use the word timid, but they might just be very circumspect, that they shouldn't be the one to destroy the laws, especially if the laws protect the rich, because these laws are used by the rich in Nigeria. They are tools of oppression used by the rich to oppress the press and citizens. So I perfectly agree with you. It is very important. And that is why collaboration that Nani mentioned is very important. If you collaborate, you can understand what is done in other jurisdictions, and you can import it to your jurisdiction and use it to sway the mind of the judges to see reason. But sometimes these are very difficult decisions for judges to make.
Thanks, Olumide. Just to make a quick observation on the point on implementation. So that judgment you referred to, yes, was a watershed moment here, but cases continue to be filed under that provision, even though it was struck down. So that goes back to the earlier point you made around the distinction between a judgment and implementation. But I know, Vrinda, you wanted to come in on this point as well.
Yeah, in fact, just on this point. So, it's interesting you mentioned Shreya Singhal. So I'm also the Off Counsel for Internet Freedom Foundation. And we have literally, moved the Supreme Court to say that it is, 2015, we're now 6 years later, we are still seeing Section 66A of the Information Technology Act being used in criminal prosecution. So, it's kind of like what you mentioned about the importance of implementation. The battle isn't won once you win. You have to kind of, carry it forward, continue sending notices, make sure that the issue remains in the public view. But just adding, I guess, one or two more examples on this idea of, judges and how do you explain either the tech to the judges and cross-country collaboration. One of the things we've seen in India, and something I think, like I also especially really believe in, is trying to rely on a wider set of jurisprudence. So traditionally, India has always relied only on US or UK jurisprudence, right? And judges often, when they want to distinguish it, just say, oh, our socioeconomic circumstances are different. We are not going to, allow these rights in India. And so I think we've really tried to broaden the collaboration base, cite judgments from across the countries, which I think kind of has helped. And going back to, I think what Nani had also pointed out, that even if you lose, it's kind of a victory. So we had this biometric, the big Indian biometric judgment, right? Aadhaar, the use of biometric ID. So one, how did we explain the tech there? I wanted to just sort of explain it. So we had judges in the Supreme Court who are 62, 63, right? And so you always are going to have that age difference. These are incredibly complex technologies about how they work, especially because the litigation went on for 6-7 years. So the technology itself evolved a lot over the 6 years. And so one of the things we really tried to rely on was expert affidavits, trying to break down. So it's not just enough to say, oh, yes, biometric IDs raise surveillance concerns, but to really try and get the experts to explain the surveillance concerns, to break it down. We tried to show, another part of our argument was an exclusion. How does it affect and discriminate against the more marginalized sections disproportionately? So, again, having expert affidavits, really going in, talking about on the ground what is happening. And then I think there's an issue of also like asymmetry of power between the government and the petitioner. So, we tried to file all these affidavits and we said, please call our witnesses. If you want to ask them questions, please call them. And kind of we weren't allowed to do that. But the government used technology and expert evidence very effectively because they ran this PowerPoint presentation. And, judges could ask questions and, really get some clarity. They came and showed the biometric machines in court. So I think it is really important to think about how to use the technology. How do you explain it? And we have at least tried to use a lot more expert affidavits. So in the internet shutdown case, it was to try and explain what does it mean to have 2G internet versus 4G, right? Like, what does that actually mean in practice? Or in the contact tracing case, what are the efficacy, false positive, false negative issues that come around Bluetooth? So that's just one of some of the ways in which I think we've tried to get past this tech hurdle. And then even, talking about winning and losing. So I think, yes, we partially won the Aadhaar case, but I think there were two benefits, even though the act was upheld. One, because it had driven this public debate on exclusion. It was something that had really was discussed repeatedly. It was brought out in court. At least the government came and said, look, we will ensure that no one is denied any food or any subsidies because they are not, because there is an authentication failure of the biometric ID. There is a different question of how well that has been implemented, but at least the government sort of came and made that statement, which was not there in the act. And I think that is a huge victory. And then talking about cross-country collaboration. So the dissent in the Aadhaar judgment was actually cited in the Jamaican Supreme Court case in Robinson, where they relied on Justice Chandrachud's dissent and said, actually, we kind of agree with this view more, and we are going to strike down the Jamaican ID system as it was at that point of time. So I think you are also seeing this idea that these similar issues, like things like digital ID, are going to get litigated across countries. So I think it's very important to have that collaboration.
Excellent. We'll now move on to the next section. We've explored the promise. Now we try to explore the perils of strategic litigation in this area. Also a reminder to our audience today, please do feel free to type in your questions in the chat window and also tweet on this issue. So now let's turn to kind of perils. Like every tool, especially in kind of almost unpredictable political environments that we often see in many of the countries we live in, can produce unexpected outcomes. Maybe that's not what you'd expected. Maybe it actually, sorry, I think I have somewhat unstable internet. Can you hear me?
Yes, I can. Yeah.
We can hear you.
Okay, sorry. So I wanted to explore this. I'll just jump to the chase, which is I wanted to explore this point around the perils of strategic rights and strategic litigation and digital rights in the global south. So Vrinda, have you been involved in cases, or have you observed cases where the petitioners had a certain outcome in mind, but the way the case progressed actually was detrimental to their cause?
So I think what I'll give the example, which is I think unfortunately I've never really had a success in any digital rights litigation. It's always been this sort of partial success. So, you know, I would love to know what it means to just win a case completely. But I think one of the perils, at least that I have found when you conduct strategic litigation, is, you know, what happens if you repeatedly fail in terms of the impact it has on the community. So for instance, if you see internet shutdown litigations, in Kashmir, it went on for 500 days, right? You had two sorts of Supreme Court judgments, and nothing really, the court in both those judgments did not look and evaluate even one shutdown order. I will after this send an article, or actually I'm just going to send it right now. It's this beautiful thing which looks at what are the different reasons for the shutdown, right? From the melting of the snow as a justification for continued 2G because it will result in rise in militancy, to the fact that elections will be coming up, to the fact that the elections were successfully concluded. So, you know, we kept on bringing these orders every 2 weeks before the judge and saying, please rule on this, please rule on this. And I think when you then don't have a Supreme Court judgment that really rules on the issue, it gives a general judgment, it recognizes rights in general. It's kind of like what Olumide was saying, it will recognize the proportionality analysis, but then how are you applying it in practice? So yes, we have this beautiful theory of proportionality, but we are seeing that, especially in national security cases, it's not being applied. I mean, even Aadhaar is a great example, right? There is a lot of proportionality analysis, but again, the application has never been that good. I think many people then believe that, oh, our courts really going to be there to help us. Like, it results in some sort of distrust for the courts. And I think what this means in practice is, in most cases, internet shutdowns will be for a limited time. They'll be for 3 days, they'll be for 1 week, right? It is very rare to get a situation like Kashmir where you have a 500-day shutdown. Most shutdowns are 3 days, 1 day. And then no one really wants to litigate that because they say you're not going to get any relief. The court is not going to, you know, give any order. By the time the matter will actually ever be taken up, you know, they'll say, oh, your internet has been restored. It's sort of infructuous, even though it really isn't. But it's sort of infructuous. We don't have time. The judicial docket is very full. So I wonder whether the fact that you're seeing courts not really engaging with the issue, you know, on the difficulties of, like, how does national security go with, you know, civil liberties? What does it mean to actually have discrimination? I think that somewhere is disincentivizing, you know, litigants from also raising some of these issues, because I think it's kind of what we're all saying, right? Like, it should be a collaborative effort. It shouldn't just be one or two groups who are going to court every time. Like, a movement will be successful. And I think one of the things in Aadhaar was it really brought together a cross-party of support, like of people who went to litigation. You had 10, 20 petitions. And that in itself at least had, you know, a movement that was sort of then just beyond what was happening in court. And so I think the perils for me are really when you consistently see a court not engaging with the issues, it can lead to people getting disheartened and saying, oh, you know, I'm not sure this is really worth it. Let's not litigate. Let's focus on something else. And so some issues get left out.
That's a very interesting perspective. And I'll pose that question to Nani as well. But before that, a question that we've got from our audience, which is Alan asks that, for others who are planning litigation, is there a network of lawyers that they can plug into in case they want to exchange ideas and thoughts? So I think that question's for you, and Olumide and Vrinda, please do feel free to share any resources over chat. So Nani, that's a question to you, which is, are there networks where people can plug into?
Sorry,
to me?
I wasn't sure who was asked to answer that question. So I think well, there's one network that's connected to RightsCon actually. This is run by Access Now and Media Defense. It's the Digital Rights Litigators Network, which is essentially a great mailing list on which litigators from around the world are connected. And then depending on the region in which you are looking or the jurisdiction in which you are looking, there are more local and regional options as well. So I'm not sure quite if I can just kind of like razzle of a list here. Olumide just put something in the chat. In the European context, there was a list that was run by La Quadrature du Net for European litigators. And yeah, there are similar setups per region as well. So, but a good starting point would be this Digital Rights Litigators Network that actually came out of a RightsCon meeting a few years ago at the time. So.
Thanks.
It has since right now seen a lot of interesting discussion on, and you know, Olumide, I would love your views also on the whole Twitter controversy in Nigeria and you know, discussing strategic litigation options. So yeah, I think it's a very good starting point. I don't think there is a list like that in India specifically, but at least globally, I find this to be quite helpful.
It is global, so I mean, you can always take advantage of it, and with that network, you can also, I mean, be able to connect with your local lawyers if there's any in your country, depending on the country. But I know Nani, I mean, Europe and the other parts of Germany and the Netherlands, Nani should be in charge of that.
Not sure I want to kind of like present myself as the network list, but
if I could bring the discussion back to this point around the perils of strategic litigation, Nani, have you seen in your experience somewhere where it's just backfired and has taken things back?
Yeah. So first I want to just like echo what Vrinda was saying about the difficulty that how sometimes litigation efforts are not necessarily as connected with those who are affected by the issues that are being challenged as others. And this is something that, you know, we all need to think about in a lot more detail. And actually is going to be like the subject of my next adventure after the Digital Freedom Fund. One of the things that I think is really important also to kind of like keep in mind is what happens after you've won your case, right? Best case scenario, you've won, the legislation you've been challenging has been struck down, and what's going to happen next? Because then it actually goes back into the what I can call the black books of legislative procedures, right? And I mentioned earlier on, like the Syria case as in the Netherlands as a good example of a win, and that's wonderful. But it's also, ironically, a really good illustration of what might be the risk of actually winning your case. So the legislation that underpinned this algorithm in the Netherlands was struck down. And the legislator went back to the drawing board and now has a proposal pending that is actually worse than the previous legislation. It's a proposal that would allow for data sharing between not only government agencies, but also private parties that are supporting in the execution of government services. So this is kind of like your worst nightmare kind of database, right? Because whatever good reasons you might be able to kind of come up with, that would be great for this kind of like initial pooling of data. Where those are going to end up and what algorithms are going to be let loose on that in the future is a really big question. And it's something that you see quite often, right? You know, like, okay, fine, we'll just, you know, we'll legislate again. And then through the back door, all sorts of new oppressive features are being introduced, or actually the new legislation is worse than was there before. So just to say, like, your win doesn't mean that you have to stop being vigilant about the rest of the cause that you were working on, right? The case, the cause, the two are interrelated, but they're not equal.
That's a very useful perspective. I mean, there's a quick follow-up question to that. Given that the original legislation was struck down, wouldn't the subsequent legislation, if it is worse, I mean, again, I'm speaking as a non-lawyer, why would someone do that? Isn't that also going to possibly be struck down in the countries that, go by jurisprudence?
I would hope so. Yes, but I think the main point is that you have to kind of try and prevent it from being adopted in the first place, right? So it's a little bit a message about like not letting your guard down. Like even if you had this victory in court, like making sure that you know what comes next isn't worse, and that you make sure that there's also that it had sufficient traction for people to want to pay attention to this. I think that one of the things, and this is something that came back like in the various comments that Olumide and Vrinda made before, is that, you know, not only judges, but also, you know, society at large tends to kind of like want to step away from things once we start using, you know, words as technology and digital, etc. It's like, oh, it's complicated, I don't want to get involved. And I think that there's an important task actually for us as civil society, as lawyers, to kind of make clear that just because you perhaps don't understand the technology itself in detail doesn't mean that you can't be engaged with the fact that it has an impact on our human rights in a digital context. And that's something that we have to kind of like continue being, you know, good at explaining to everyone. Public at large, to judges, to courts, to people who are enforcing legislation. It's actually about, you know, the issues at stake and not so much about like how the tech practically works.
If I can just add to that, this actually goes back, I mean, it connects what Nani was saying to also what Olumide had earlier pointed out, and maybe a bit, I just saw the question that had been posed. Which is that, you know, when you also celebrate a win, so this goes back to the Shreya single judgment, which struck down section 66A, you know, which obviously was completely unconstitutional and was rightly celebrated for that perspective. However, in that judgment, there were two other provisions also that were challenged. One was the blocking power of the government, and the second was the intermediary liability safe harbor provisions that were enshrined in the law. And, you know, they were both upheld with sort of very minor tweaks. And because all the sort of celebration around the judgment was on this one aspect of 66A, the court's ruling in those two parts sort of was almost ignored, like even in like wider critical commentary or, you know, public opinion. And we now see that really becoming a problem because, you know, some of you may know India has passed these new intermediary rules that we've also challenged in court, but which really do come from the fact that the earlier rules were upheld completely. So I think it's also important that when you end up focusing on one win, you have to make sure, you know, what is happening to the other provisions and the other laws, etc. And so I think there was this kind of absence of real public opinion, like general public opinion on those other provisions. And we're now seeing that come back to bite us.
Yeah, that's a very interesting perspective and something that's happened and all for all of us to think about. At that point, Olumide, I also want to bring you in case you have any perspectives to share on this question of the perils of strategic litigation.
Yes, I have. I'm going to take a cue from what Vrinda and Nani said. I mean, it's also applicable to Nigeria, but the new trend in Nigeria now is when judges award costs against applicants who have brought strategic litigation. It's a new trend now. So it tends to discourage people from going. I have been awarded in 2 different cases, cost of about $1,000 against me in about 2 different cases in data protection. You know, you now have to, even if you were not planning to appeal because of those costs, you really need to appeal. I mean, so for some other applicants, it might discourage them from wanting to even strategically litigate matters because you don't want judges to begin to just award. Sometimes they insult you big time. They call you names, or some unprintable names. And so those are the things that most times discourage people from wanting to litigate digital rights or strategic litigation in Nigeria. But of course, for people who really know what they want to achieve, just like Nani said, sometimes it is not even about winning. Even when you lose, sometimes you might have achieved your objectives and your aim. But another problem in Nigeria is the justice system is too slow. So you could litigate one case for 5 years, 10 years, one case. It's extremely slow. So by that time, you might have even lost him. I mean, just like Nani said, the government might have even gone to the court to insert more clauses in that same law you're trying to challenge, some very, some worst case scenario for you. So those are the perils that we have experienced in this part of the world.
Yeah, as the economist Keynes said, in the long run, we are all dead. So I guess justice delayed is justice denied. There's a question we have from Jayashree in the audience, which is, as you litigate these matters in courts, do you worry that the progress that you make or the litigation that you initiate might cause some other related movements to actually see certain, have some kind of regression? I know, Vrinda, you have co-authored a paper with the Internet Democracy Project where you looked at it in the different direction, which was litigation meant to kind of protect women was actually harming digital rights. Do you see it the other way around as well?
Yeah, I'll just send a link to that paper. But basically what we had looked at that paper was all these concerns about gender rights, right? So, oh, the court saying we're trying to protect women. And this is kind of two ideas of like women as like subjects and women as objects, right? So looking at, oh, the ideal Indian woman, so this is all your patriarchal notions of morality and decency. And in trying to uphold those notions of morality and decency, there's a real regression on digital rights issues, right? You end up saying, yes, you should regulate OTT platforms, for instance, or yes, you should expand intermediary liability, ensure proactive filtering, end-to-end encryption, to solve like actual problems of say CSAM content online, but then without realizing what those implications for digital rights are. And I think, yes, the reverse is true to a bit in the sense of when we often litigate digital rights, we don't see how it impacts like women or marginalized people more. Like you tend to think of it as, oh, you tend to think of yourself almost as the litigant, as the person affected. And I think, I mean, one of the reasons for me, Aadhaar became something that also was a very important judgment is honestly, it opened my eyes in a way that you always, we all know we are privileged, and I come from a very privileged background, but really seeing that, learning from people on the ground, seeing how it was affecting people over these like 5-6 years, I think that brought in a nuance to our arguments that I hope we were able to make some impact there. And I think that does happen because the general arguments, and often also in the op-ed pages, right? So for instance, people were criticizing biometrics, Aadhaar when it was introduced, since it was introduced. But at that time, the opposition was very small. It's like Nani said, people said technology, privacy, and everyone was like, oh my God, what are you talking about? This is great. And then when it affected the upper middle class, when your mobile phones and your banking systems were being linked, suddenly everyone woke up to the dangers of biometric ID. But no one really, in the cities really cared about how it was affecting someone in a village who was trying to get, ration or food. And I think often, I think you do sometimes tend to lose sight of how it is affecting people, on the ground, and who is it that you're litigating for, and who are the people who are not even able to come to you to make their case, right? I mean, just I think trying to understand those structural barriers. So, for instance, a thing that I honestly learned during the litigation, I think it just shows my blinders, unfortunately, more than anything, is we were challenging. So right now, recently, this vaccination portal that's there on the Indian, that the Indian government is using to book vaccine slots, and, huge issues of digital divide, huge issues. So we raised those issues in court through the amicus. We had submitted a note. And one of the things, because of previous litigations that we had done, was in how this was not, it was not accessible. It was not a website that was, that would help visually, impaired persons, because it required a captcha to be able to book a slot. There was no audio captcha, there was no other OTP mechanism. So the only way to book a vaccine slot was doing it online on a website, which requires a mobile phone or an app. Initially, it was only in English. So, as you can imagine, just like large parts of people being excluded by each and every requirement, any person could just, register up to 4 people. So you can't rely on, lots of, you can't even rely on family and friends. And you had to enter a captcha. So actually just effectively excluded this entire population. And so I think, I'm not sure if I've really answered your question, but I think it helps to think about perspectives outside our own to enrich the litigation. So I think that's how I would imagine, you can sort of enrich both. And the other very short 1-minute point that I would like to make is also realizing sometimes, I think, and maybe Olumide and Nani, I would love to hear your views on when sometimes we think, so many times when we are deciding, we think the time is not right. Courts may not right now give us a favorable opinion. It may actually result in a regression because we will lose the challenge. So let's keep it open. Let's keep the gray area open for a while and then challenge it. Because sometimes the gray area does sort of help you, because even governments are a bit diffident. So if you see internet shutdowns, There was no legal basis to do it till 2017. So the legal basis was questionable. The government introduced a legal regime, which was the telecom suspension rules in 2017. The number of shutdowns shot up. Like, there is just such a clear marked change from when the rules came in. So I think this is something I've always thought about as well.
Thanks, Vrinda. Nani, would you want to come in on that point? Like, digital rights litigation, is there a risk that it affects other kinds of movements that are ongoing?
Absolutely, but that applies across the board, right? I mean, I also don't see digital rights as a separate area from human rights more generally, right? It's human rights issues in a digital context. And I think it's your obligation, basically, once you start considering going down the path of strategic litigation, to consider what are the kind of the adverse effects that it could have on other issues. And ideally, actually also discuss with others who are working in those fields that might be adjacent to the one that you are focusing on, to see like if there's anything that you can do to mitigate for those risks. Is there a way in which you can approach, as I was saying earlier, the incremental approach? Is there a way in which you could frame your challenge a bit more narrowly in order to kind of like clearly stay away from, you know, the slightly more gray areas or even the danger zone, if I can put it that way? So it is something that you should be doing. Like the last thing you'd want to do is kind of like be so single-minded that you focus only on that particular thing that you are interested in, and therefore kind of like raise the bar to such an extent for others that they are going to be spending decades to kind of like fix the mess that you made. No one's going to love you for that. And also overall, if you consider that all of us are trying to, you know, pursue a world in which human rights, in whichever context, are better respected and for everyone, this is not where you would want to go. So I think taking a more holistic approach, yeah, it's, in my view, that's mandatory.
Thanks, Nani. This has been enlightening for me, this notion of the holistic approach and being integrated with the system, right? So that's been one of my major takeaways from this conversation. I do want to move us to the conclusion in the last 6 minutes that we have, but before that, we have a comment from Usha Ramanathan, which I think is an important one, and therefore I can read it out in full, that cases cannot be fought only in court. Judges and lawyers have to be introduced to what the concern with tech is before the case is taken to court, especially when you consider that judges don't belong to a generation that understands technology and what it can do, and the same with senior lawyers. And so it has to be cast in language that they already understand, like privacy, surveillance, censorship, exclusion, etc. So I think that's also a thread that we have seen come up in this discussion several times. In the last 6 minutes of this conversation, I want to turn to concluding thoughts, especially from the perspective of someone who hears this conversation and says, here's an interesting tool. I'm kind of very intrigued. I think it might be relevant on issues I care about in my country. What is kind of the 101 kit that person should know? Like, where should that person get started? So why don't I start with Olumide on this question? That Olumide, where does this person get started?
Okay, thank you. So within my 1 minute, I'll quickly mention, I'll go back to what Nani and Vrinda said about the new issues that you never thought of. For example, I was briefed to challenge cryptocurrency regulation in Nigeria. At that time, it wasn't regulated. So, I mean, but police on their own would just pick up people dealing with crypto. So we wanted to go to court to challenge the police activity. The part of discussions we had with the stakeholders was, come, this area is not regulated yet. It is better we leave it the way it is. And let us begin to do things our own way. So if you go to court, you will push them to regulate it. And the regulation might not be to our own advantage. So I agree with Nani and Vrinda that at times, strategic litigation might not necessarily be the answer. It might just be good for us to watch. So, I mean, on my own, to start up with strategic litigation, the most important thing for me is understanding the terrain and understanding the parties, understanding the stakeholders. It is extremely important. So if you want to litigate digital rights, you need to know who are the organizations involved in digital rights. It makes life a lot easier for you. either as a lawyer or as an interested party or as someone who is an enthusiast of digital rights. You need to know the people who are in the field. So, I mean, since 2016, I've been looking out on the internet, looking out for organizations, looking out for events, looking out for practitioners, looking out for writers and researchers who have written on it so that I could learn from it. And if there are things we need to do around collaboration, easily we can sit down and talk about it and see how we can do. So for me, first of all, understand the people in the field. Then secondly, determine the aspect you want to face. Because this thing is very wide. Yes, we say it is digital right, but it's extremely wide. So there are some part of digital right we don't even talk about. In December, my organization did a short expose on the variants of digital rights. We understand that people most times don't talk about the consumer aspect of it. We don't really talk about consumer rights when we're talking about digital rights. Most times we face expression, we face privacy and inclusion and all those things. We don't look at the other parts of it. For example, I'm not so sure we've seen so many litigation on cryptocurrency. It's all over the world, people don't even understand how to approach it. And we understand that governments all over the place have been clamping down on cryptocurrency. This is some interference with digital right to own property, to acquire property. And it's not been so there could be areas that you want to face. And I'll just stop from there so that Nani and Vrinda can also take the other part.
Thank you. We have exactly 2 minutes left. So if both Vrinda and Nani do it in 1 minute, we can have both of your perspectives here. So Vrinda, over to you first.
Yeah, well, I'll just say 30 seconds. I think I would agree everything what Olumide said, and just add, I think it's also important to think about which court you go before. Like this is especially, I think, relevant in a country like India. It's not always good to go to the Supreme Court. It's not always necessarily good to go to Delhi High Court because you live in Delhi. I think it's really important to look at, what are the right courts to go to. Also, whether you should bring a matter as a petition, like as a writ petition or as a public interest petition, because in India there is some distinction. So I just think like it's also important to think about these more practical issues about when to litigate, how to litigate, before whom to litigate, and when to push for your case to come up also, I think is another, like Olumide said, these cases go on for years. So when do you kind of push for it to be heard again?
Thanks, Vrinda. Nani, any last thoughts?
Yeah, I'm just going to +1 both of those interventions and emphasize how important it is to make sure that you don't try to just do everything by yourself, but rather make sure that you work together with partners who are very talented in all the things that you perhaps might not be as talented in, who are great in advocacy, who are great in campaigning, etc. And last but definitely not least is how you are going to make sure that you're going to keep touch with the base that you are allegedly representing in your case. Like, who are the people for whom this case is being litigated, and how can you make sure that the legal strategy keeps on aligning with their interests throughout the process.
Thank you, Nani. And this has been an enlightening conversation, and I hope our audience and the panelists have enjoyed this and learned as much as I have. For me, a couple of threads that really stood out was this question of just understand the politics around it, the thing that Olumide said at the end, understand who is the litigant, who are you representing, etc. The points Nani made initially about you are part of this movement, and think of yourself as one tool and one element of that movement, and there's a whole bunch of other actors who are doing other things in this movement. And then the points that Vrinda made about, sometimes are we, what are some negative consequences? Are we celebrating too early? Are we focusing too much on one victory and forgetting the other downsides in that same very judgment? So these have all been interesting threads. I hope we will find forums to talk about this again. But as a concluding thought, really want to thank the panelists for what I felt was a really informative discussion. So thank you so much.
Thank you all for the great conversation. It was really lovely.
Yes.
Thank you.
Yeah, thank you so much.